January 22, 2020. Today I testify, and Joe Schreibvogel sentenced to 22 years in prison. I woke up thinking about Mama Jackie in her white room. I could see it in such great detail that it's not hard to describe. They had added a second floor to the modest little 2-bedroom, 2-bath home on Lake Keystone. I loved that the original house was rough-cut cypress. It blended into the surrounding cypress trees in the expansive yard. She painted it green, and I always felt bad for the walls because I thought they were beautiful and rugged and had such character, but it had been painted over and hidden for trending style's sake. Upstairs, she had a blank slate, and it was white shag carpet, white sheer drapes on the huge windows that overlooked the lake, a squarish 60s-style white couch and matching chairs. Everything else in the room was gold, with the exception of the floor-to-ceiling cranberry velvet curtains, trimmed in heavy gold fringe. These hung on the south wall behind the bed. There was a gaudy gold coffee table that she later sold to me, gold shelves holding every Hummel porcelain child ever made. For the first time today, I wondered if her collecting of those children was to try and make up for the baby girl she'd lost. I hadn't filled that void, but neither did the dolls. I don't know why this is on my mind on the day that I will plead that the court keep a monster off the streets. Maybe some connection to all of the innocents he harmed and killed. My witness statement to the court at the sentencing hearing. The court said, "You may proceed, Ms. Baskin." The witness said, "That was me." Thank you. The conviction of Mr. Schreibvogel Maldonado-Passage was made based upon only a handful of vivid examples of his malicious intent to murder me. The prosecution didn't need to present the daily barrage of threats to harm, rape, or kill me that were my daily experience for the last 10 years. The evidence showed that over the course of many years, he tried to coerce others into killing me, and in the end resorted to hiring others to kill me. If he had succeeded in carrying out his murderous plan, you might be calculating now what the value of my life had been. It's nothing short of a miracle that I'm able to stand before you today and ask that you consider all that he was able to take from me. Because of his constant threats to kill me, I have found myself seeing every bystander as a potential threat. There is nowhere that I have felt safe, and worse, no way that I feel I can safeguard those around me. So many of his threats involved blowing me up so that he could thrill over seeing me burn to death. Even from jail, he gleefully talks about the prospect of me dying a fiery death. Anyone near me, my daughter, my mother, my husband, my volunteers, my staff, they have all been in peril because of his obsession with seeing me dead. I live with the guilt associated with the danger that my mere presence brings to each of them. There are two important things the court might not know from the trial. The first is important because I believe that Mr. Schreibvogel Maldonado-Passage will claim ill health to minimize his sentence. In the 15 years that I have known him, as a way to get sympathy, he repeatedly claimed to be the victim of various diseases, including cancer, and worn a knee brace and a cane that he clearly does not need. The second thing is that over the years, numerous people who worked at his zoo contacted us after they left the zoo and told us that every single day he would rant about me. They all characterized him as obsessed. As you consider his sentence, I would just like you to take into account that if this vicious, obsessed man is ever released from jail, my life and my family's lives will return to what it was like during the decade leading up to his arrest. If he completes his sentence and is released, we will end up spending the rest of our lives constantly looking over our shoulders for a threat to our lives. I hope you will give us as many years free of that threat as you can. Thank you. The court said, "Thank you, Ms. Baskin." The sentencing transcript was 83 pages long, with a lot of legal discussion between the court and the attorneys. I didn't include it here in text, but it is linked in my diary. Joe ranted and raved for pages, and then the court issued this sentence. The court said, In imposing the sentence in this case, I am mindful of my statutory duty to impose a sentence that is sufficient but not greater than necessary to fulfill the objectives of sentencing under the Sentencing Reform Act, and I take into account the factors mandated by 18 United States Code Section 3553, including the purposes for sentencing set forth in Section 3553A2, which state the need for the sentence. And Mr. Early went through these very carefully, and it was a very thorough job. But just to repeat, to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment for the offense, to afford adequate deterrence from criminal conduct, to protect the public from further crimes of the defendant, and to provide the defendant with needed educational or vocational training, medical care, or other correctional treatment in the most effective manner. And I further consider, as set forth in 3553A, the nature and circumstances of the offense and the defendant's history and characteristics, the kinds of sentences that are available, the need to avoid unwarranted sentencing disparities among defendants with similar records who have been found guilty of similar conduct, the advisory sentencing guideline calculation, and the relevant guidelines policy statements, and the need to provide restitution to any victims of the offense. In terms of those factors, I place significant weight on the seriousness of those offenses. As to counts 1 and 2, the defendant was convicted of counts involving efforts to have an individual who he considered a professional rival, a threat to his income, violently murdered in 2 separate schemes by 2 different men. The pattern of conduct is particularly troubling. It escalated exponentially from Mr. Maldonado-Passage, initially engaging in some verbal social media banter, to increasingly threatening and outrageous videos, culminating in the defendant's hiring of Alan Glover to carry out this threat, and then later hiring an undercover agent to commit the murder, at least by all accounts when it became unlikely Mr. Glover was going to be successful. An objective look at all of the evidence in this case leads to the fair conclusion that the defendant was consumed, if not obsessed, with silencing Carole Baskin. There has been a great deal of discussion about what the likelihood of Mr. Glover actually accomplishing this, and talking about what amounts to his incompetence, unpredictability, which cuts both ways. Who knows what this man would have done? With regard to the Lacey Act and the endangered species counts of conviction, the offenses were no less serious in the context of the statutes. And I say that, which I understand compared to the murder for hire convictions, which dealt with a human life. I don't mean to compare the lives of those animals, but in the context of those violations, those were extremely serious. And while I would agree that those wildlife counts are consumed by the guideline calculation regarding counts 1 and 2, and would result in no increase in the calculation, I do disagree with the position that these violations should not be considered significant criminal conduct. There is certainly an argument that the wildlife counts are individually significant, but I specifically find that they are significant in light of the volume of the violations. 5 violations involving the unlawful killing of endangered species. 4 violations resulted to the unlawful sales and of endangered species, and 8 violations regarding the associated veterinary certifications and documentation for the transfer of these animals. Those violations collectively demonstrate the defendant was engaged in a systemic trafficking of protected animals, which included the unlawful killing of a number of them. And it is immaterial to me that the defendant disagrees with the interpretation of the statutes or what is included as a protected animal under the Endangered Species Act. In imposing a sentence today, I do intend to craft a sentence that provides for punishment and deterrence resulting from the wildlife violations, although that will not result in an upward variance, but will instead be taken into account within the advisory guideline range. I place significant weight on the need for the sentence to promote respect for the law. There is minimal evidence in the record demonstrating any respect the defendant has for the law during the course of these criminal acts. A significant example of that, in spite of your prosecution for these very violations, Evidence was introduced at trial of your attempt to broker the sale of a litter of lions for financial gain for your husband from the county jail while you were awaiting trial. I also place significant weight on the need for the sentence to serve as a deterrent. And as Mr. Early correctly pointed out, there's two components of that: specific deterrence and general deterrence. So, not only a specific deterrent for your criminal conduct, but also a general deterrent to others who may be engaged in or considering similar criminal conduct. I note in particular that there was testimony during your trial in regards to the falsifying of documents associated with the transfer of these animals, that those actions were common in the exotic animal community, and multiple references to the lack of enforcement of the governing statute. I fully intend for your sentence to serve as a deterrent for any person, including you, who would choose to ignore the law. Finally, it is of paramount importance in this case to provide just punishment for your offense and protect the public from further conduct you may engage in. While you may be effectively out of the exotic animal business, the issues which motivated you to solicit the murder of Carole Baskin remain. The sentence I impose will certainly advance the goals of punishing you for all of these offenses and will hopefully protect the public from any future offenses. In arriving at that sentence, I have considered the nature and circumstances of your offense, Mr. Maldonado-Passage, as well as your history and characteristics. The nature and circumstances were thoroughly presented at trial and have been outlined in the PSR, which is the pre-sentencing investigation report, in great detail. Your history and characteristics were also well presented in the pre-sentence investigation report and your sentencing memorandum, and I have considered those as well. It does weigh in your favor, in making a sentence determination, it does weigh in your favor, that you have a lack of any meaningful criminal record. I have also taken into consideration your charitable acts, including the providing of meals and admission to your park for the underserved during a number of holidays, and which include a number of instances of your engagement with terminally ill children and adults who I am sure, as you suggested, appreciated being around, spending some time with the animals that you kept at your facility. The kinds of sentences that are available to you are limited. The facts and circumstances of this case demonstrate that any sentence other than a significant term of incarceration followed by a term of supervised release would not fulfill the purposes of sentencing as provided for in Section 3553. As to the consideration of the need for the court to avoid unwarranted sentencing disparities, I know you have argued in your sentencing memorandum that the fact that you are the only defendant facing punishment for these offenses, suggesting that other individuals were criminally responsible, would result in an unwarranted disparity. I do not give weight to that argument, as the factor to be considered is in regards to defendants who have been found guilty of similar conduct. It is not a charging disparity, it is a sentencing disparity. Uncharged individuals are not the subject of consideration for this factor. And finally, I also take into consideration the advisory guideline range and the relevant guidelines policy statement. Mr. Maldonado-Passage, please stand. It is the judgment of the court that the defendant, Joseph Maldonado-Passage, is hereby committed to the custody of the Bureau of Prisons for a total term of 264 months. This sentence consists of 108 months as to count 1, 108 months as to count 2 to run consecutively, 12 months as to each of counts 3 through 11, the misdemeanor counts, to run concurrently with the other counts, and 48 months as to each of counts 12 and 15 through 21 to run consecutively through the other counts, although concurrently with each other. Due to your inability to pay a fine is waived. It is recommended that you participate in the Federal Bureau of Prisons Inmate Financial Responsibility Program at a rate determined by the Bureau of Prisons staff in accordance with the program. Upon release from imprisonment, the defendant shall be placed on supervised release for a term of 3 years. This consists of 3 years on each of counts 1, 2, 12, and 15 through 21, and 1 year as to each of counts 3 through 11. All such terms to run concurrently. Within 72 hours of release from custody, the defendant shall report in person to the probation office in the district in which the defendant is released. The defendant shall comply with the standard of conditions of supervised adopted by this court and shall not possess a firearm or other destructive device, and shall cooperate with the collection of DNA as directed by law. The court is not imposing community service. The defendant shall comply with the special conditions listed in Part D of the pre-sentence investigation report, which will include the substance abuse evaluation and care, and will also include the exotic animal and protected animal provisions as listed and previously discussed. Paragraph 151 does state that the court should impose a condition where Mr. Maldonado-Passage, as a condition of supervised release, should not possess any species of animal listed as endangered or threatened under the Endangered Species Act, and shall be prohibited in the sale, transportation, or other transfer of such animals, of their hides or body parts. The defendant shall pay to the United States a special assessment of $100 per felony count and $25 per misdemeanor count, for a total of $1,225, which shall be due immediately. Defendant is further advised that from such judgment, sentence, and conviction, the defendant has the right of appeal to the United States Court of Appeals for the 10th Circuit. Also, if the defendant cannot pay costs of the appeal, the defendant may apply for leave to appeal in forma pauperis, that is, without payment of costs for the transcript of the trial record and an attorney at government expense. Notice of appeal must be filed with the clerk of this court within 14 calendar days, or the defendant may request the clerk to now spread the same of record. Mr. Maldonado-Passage, you have conducted yourself for years, doing as you pleased, whether in your actions and reactions to your conflict with the victim in this case, or in regards to your handling of these protected animals and the laws regarding their ownership. It is clear from the evidence in this case that you are convinced that you always know better and expect your explanations and directives to be taken at face value. You have routinely attempted to explain away your conduct, including today, blaming those around you, whether that is Carole Baskin, law enforcement, business partners, or your own employees. Sir, in spite of what you may believe, you are not the only in-step person in an out-of-step world. If you're enjoying my diary, please like, share, and subscribe. You can find other ways to connect to me over at bigcatrescue.org/Carole.Baskin.